A single Supreme Court ruling just rewrote the rules of American elections. And it might have already decided who controls the House of Representatives.
Yeah, we essentially watched an unprecedented mid-decade redistricting arms race completely kick off in 2025, right ahead of the 2026 midterms.
And it really started with Texas, right? Just aggressively redrawing its maps to secure these Republican gains.
Exactly, which then triggered this massive retaliatory gerrymandering from Democratic-led states like California. But the ultimate bombshell dropped on April 29th, 2026.
Right, when the Supreme Court issued that 6-3 decision in a case called Louisiana v. Callais.
Right, and that ruling, it fundamentally altered the Voting Rights Act. I mean, it sparked an immediate, almost frantic redrawing of congressional maps across the entire American South, just months before voters were supposed to head to the polls.
So if you feel like the landscape of American elections just shifted under your feet, you aren't imagining it. Today, we are doing a deep dive into the mechanics of these new rules.
Yeah, looking through the Supreme Court opinions, along with analysis from the Brennan Center and the Brookings Institution.
We really need to figure out how they work on the ground, why the Supreme Court made this monumental shift, and honestly, what it means for the future of your vote. Because when politicians start changing the rules of the game while the clock is still running, you need to know how the score gets tallied.
You really do. And to understand the impact of the Callais decision, we first have to look at the sheer chaos of the political landscape leading up to it. Because normally, states redraw their congressional maps once a decade, right after the census.
Right. You count the population, you see where people moved, and you adjust the district lines. Simple.
Simple, yeah. Changing those maps in the middle of a decade, just for partisan advantage, is incredibly rare. I mean, between 1970 and 2026, states only did it twice.
But the 2025 to 2026 wave just threw that historical norm completely out the window.
Oh, complete.
Donald Trump publicly pushed Texas to redraw its maps, specifically to protect a very narrow Republican House majority, and Texas succeeded, locking in 5 seats.
And then, Missouri, North Carolina, and Ohio jumped right on board. They passed new maps designed to eliminate Democratic seats and pad the Republican column.
But the Democratic states hit back hard, right?
Right, they did. California actually altered its independent redistricting commission rules specifically to net 5 additional Democratic seats.
Wow.
Yeah, and Virginia tried to gain 4 seats through a constitutional amendment, though their state Supreme Court and eventually the U.S. Supreme Court struck that attempt down because of procedural issues.
So the statistics on this whole scramble are just staggering. Ultimately, 8 states successfully finalized new mid-decade maps. And when you look at the national board going into this chaos, the United States had 148 majority-minority districts. Democrats held 122 of them.
Right.
In California alone, 85% of its 52 districts were majority-minority.
So the stakes literally could not be higher. Politicians realized that with a divided Congress, finding a few extra seats through the map drawing process is, frankly, just much easier than convincing millions of swing voters to change their minds.
I mean, it's like a football game where both sides are out there grabbing paint rollers in the middle of the third quarter, right?
Yeah.
Just repainting the out-of-bounds lines to give themselves the ball.
That is a great way to put it.
But if both sides are just painting over the lines, who is the referee here? Like, why haven't politicians always just been doing this?
Well, for decades, they couldn't. The Voting Rights Act of 1965 acted as this massive brick wall. The act required states to draw majority-minority districts to ensure minority voters had a fair opportunity to elect their preferred candidates.
Okay, so that stopped them.
Exactly. Politicians generally avoided constant mid-decade redistricting because moving those lines invited massive, expensive, and usually unsuccessful legal battles under the Voting Rights Act.
Got it. Which brings us to April 29, 2026. The Supreme Court steps in with Louisiana v. Callais. So following the 2020 census, Louisiana drew a map with only one majority black district. And a lower court ruled that under the Voting Rights Act, Louisiana actually needed a second majority black district to fairly represent the state's population.
So the state drew a new map featuring District 6. And this is a second majority black district that basically stretched across the state to connect black populations in places like Baton Rouge and Shreveport.
But then a group of non-African-American voters sued. They claimed this new District 6 was actually a racial gerrymander, which they argued violates the Equal Protection Clause of the 14th Amendment.
Yes, and this creates a really fascinating legal paradox.
How so?
Well, you have the 14th Amendment saying you can't treat people differently based on race.
Right.
And then the Voting Rights Act is essentially saying You must look at race to ensure minority voters get fair representation. Those two ideas are on a direct collision course.
That is a huge conflict. So how did the court handle it?
Well, Justice Samuel Alito, writing for the 6-3 conservative majority, navigated that collision by just striking down the map entirely.
Wow.
Yeah. The court ruled that the Voting Rights Act did not actually mandate the creation of that specific second district. And because the act didn't require it, using race to draw those specific lines became an unconstitutional violation of the Equal Protection Clause.
Which is just a monumental shift in how courts evaluate election maps. I mean, for decades, courts used an effects test, right?
Exactly, the effects test.
They simply looked at the map and asked, does this map dilute minority voting power in its practical effect? But the Supreme Court just threw that out. They shifted the standard to an intent test.
Right. Now, courts have to ask, did lawmakers intentionally discriminate based on race when they drew the lines?
Shifting from effects to intent, I mean, that rewrites the entire playbook for civil rights lawyers.
It completely changes the game. The court established a strict rule about disentangling race from politics. Because the Supreme Court previously ruled that partisan gerrymandering, drawing lines to favor Republicans or Democrats, is completely legal in federal courts. So under this new ruling, if a state claims they drew their lines purely for political gain, plaintiffs now carried a special burden. They have to prove that race, and not just raw partisan politics, was the true motive behind the map.
But wait, we have to look at how this plays out in reality, because race and political affiliation overlap heavily in the United States.
They do?
Black voters overwhelmingly vote for Democrats. So if a mapmaker carves up a black neighborhood and their stated goal is just to hurt Democrats and protect Republicans, how do you definitively prove they did it because of race? Like, do civil rights lawyers need to find an email from a politician explicitly saying, let's disenfranchise this specific racial group?
That is the exact hurdle civil rights advocates are facing now. Finding a smoking gun email in modern politics is, frankly, nearly impossible. Lawmakers know better than to leave a paper trail of racial animus.
All right, they're not going to write that down.
Exactly. So if a map maker can stand in front of a judge and say, we weren't targeting minority voters, we were just targeting Democratic voters, the map is highly likely to survive a legal challenge, even if the practical effect completely wipes out minority representation in that area.
Proving that kind of secret intent just feels incredibly difficult. But the court added another requirement for challenging these maps too, didn't they?
Yes, they did. We have to look at the Jingles test.
The Jingles test.
Yeah, this is the legal framework civil rights groups use when they challenge a map. Previously, the very first step of the Jingles test was just a baseline demonstration.
Right.
Plaintiffs just had to show a sample map, proving that a minority group was large and compact enough to form a majority in a reasonably drawn district.
So they basically just had to prove that a fair map was mathematically and physically possible.
Precisely.
Yeah.
But the Callais decision created strict new rules for this first step. Now, plaintiffs cannot use race as a factor to draw their alternative map at all.
Wait, really? Not at all?
Not at all. And furthermore, their proposed map must achieve all of the state's legitimate political goals just as well as the state's own map did.
Okay, meaning if the state drew a map with the goal of hitting a specific partisan distribution, say, guaranteeing 6 safe Republican seats, the plaintiff's alternative map must also guarantee those exact same 6 Republican seats, while somehow improving minority representation without using race to draw the line.
Yes. That is exactly what it means. And on top of that, the court instructed lower courts to ignore historical discrimination entirely. Judges must focus only on evidence of present-day intentional discrimination.
I mean, it's like hitting a totally unwinnable video game boss level.
Yeah.
You have to beat the boss, but you aren't allowed to use the jump button. Oh, and you also have to collect every single coin the boss wanted to collect along the way. If you miss one coin, you lose.
That analogy is spot on.
Yeah.
And Justice Elena Kagan really hammered this point in her fierce dissent. She argued that these new rules basically render Section 2 of the Voting Rights Act all but a dead letter.
Wow. A dead letter?
Yeah. She pointed out that this ruling effectively revives an intent-based standard that Congress explicitly outlawed way back in 1982 when they amended the Voting Rights Act.
Well, we do need to look at the conservative legal rationale here, too, because it really highlights a massive philosophical divide on the court. Justice Clarence Thomas wrote a concurrence arguing the Voting Rights Act shouldn't apply to districting at all.
Right.
What is the core legal logic driving that side of the bench?
So the conservative argument is deeply rooted in a very strict interpretation of the Equal Protection Clause. Justice Thomas argues the Voting Rights Act was originally meant to protect access to the ballot box, stopping things like literacy tests and poll taxes.
Just getting to vote in the first
Wait,
place.
he argues it was never meant to guarantee proportional racial representation in Congress. The conservative justices view categorizing citizens into racial blocs to draw political lines as inherently divisive and unconstitutional.
Okay, I see.
From their perspective, demanding colorblind map drawing is the only way to satisfy the 14th Amendment, regardless of the political fallout.
And the ink wasn't even dry on this ruling before states began weaponizing these new rules, was it?
Oh, not at all. The fallout across the South was immediate. Louisiana actually canceled its May primary election entirely so the legislature could redraw its maps.
That is wild. Think about what that does to a local election ecosystem. Campaigns just pause, millions of dollars in advertising are wasted, and voters are left completely confused about when or where they're even supposed to vote.
It's pure chaos. And Florida passed a new, highly partisan map the very same day the Supreme Court ruling came out.
The same day.
The exact same day. Tennessee moved quickly, too, and they eliminated its sole majority-minority district entirely.
And what about Alabama? Didn't they jump right back into the fray?
They absolutely did. They had a legislature-drawn map that a lower court had previously struck down for intentional discrimination. But after Callais, Alabama asked the Supreme Court to reinstate that map.
And did they?
Yeah, the Supreme Court agreed to vacate the lower court's ruling and sent it back down to be reevaluated under these strict new standards.
So let's look at the national political math here. Analysts are warning that up to 122 Democratic seats are at risk nationwide because of these new mid-decade maps and the weakened Voting Rights Act.
Yeah, the numbers are huge.
Conservative commentators actually project this ruling could net Republicans at least a 12-seat advantage going into the midterms.
But, those projections assume everything goes perfectly for the map makers. And this aggressive strategy introduces a major risk. It creates the very real possibility of what political scientists call a dummy mander.
Okay, the dummy mander. I've heard this term. This is when a party gets so greedy trying to eliminate the opposition that they actually sabotage themselves.
Exactly.
How does that actually work on the ground in a place like Tennessee, for example?
Well, to eliminate a Democratic district, map makers use a tactic called cracking. They take a highly concentrated Democratic area, like Memphis, and they literally carve it up into pieces.
Okay.
They take, say, 60,000 Democratic voters, and they absorb them into the surrounding safe Republican districts.
So they dilute the votes so much that the Democratic district just disappears.
Right.
But wait, if you take 60,000 Democratic voters and dump them into 3 neighboring safe Republican districts, you just injected thousands of opposing voters right into your own backyard.
You did.
Doesn't that physically thin out the Republican margin of victory in those surrounding areas?
That is the exact mechanism of a dummy mander. When you spread your opponent's voters across your own safe districts, you leave yourself far less room for error. You might turn a district you usually win by 20 points into a district you only win by 6 points.
Wow. So if a massive blue wave happens and voter turnout shifts unexpectedly, couldn't this totally backfire?
Oh, absolutely.
I mean, if public opinion swings sharply against the party in power, those newly narrowed margins could easily be overwhelmed. Instead of securing a safe majority, a party could accidentally hand multiple seats right back to their opponents.
It is an incredible gamble. Map makers are stretching their advantage as thin as mathematically possible to maximize their seat count. And they're basically just praying the political winds do not change.
Well, regardless of whether it backfires, the long-term impact on how we are represented is profound. We watched states realize they could just redraw the lines whenever they wanted, provided they had the political power in the state house.
Yeah.
And then the Supreme Court removed the primary legal roadblock that used to stop them from breaking up minority communities to achieve those political goals.
Right, and analysts are warning that state congressional delegations are increasingly being legally engineered to be monolithically red or blue.
Just totally one-sided.
Right. If a state's map is designed so that one party wins every single seat, despite the fact that the opposing party consistently wins, say, 40% of the popular vote statewide, the House of Representatives stops reflecting the actual population. It starts to resemble the winner-take-all electoral college.
Which leaves us with a really uncomfortable question. If the district lines dictate the outcome before a single ballot is even cast, does the House of Representatives still represent the people? How do you stay motivated to participate in a democracy when the rules get rewritten in the middle of the game and you're just forced to live with the final score?